Hello and welcome to another episode of Legal Wrangle on international taxation. We bring you 5 cases in this episode relating to the arm's length rate of corporate guarantee, availability of DTA benefit to an Indian agent for taxes paid abroad, Section 44BB benefits, receipts from offshore supply equipment and availability of Article 8 benefit for code sharing agreements of airlines. Let's go on to our first case. The Assessee Everest Kento Cylinders is an Indian company manufacturing gas cylinders. It had set up foreign subsidiaries in major markets for expansion of its business. These companies were granted loans by ICICI Bank Bahrain branch, for which the assessee had provided the bank a corporate guarantee. The assessee had also paid a guarantee commission to ICICI Bank India. However, it had charged its AEs a lower amount as guarantee commission. The differential was attributed to the strategic business interest of the assessee in its AE. The question before the court related to the arm's length rate of guarantee commission and whether there is a difference between guarantees issued by commercial banks as against a corporate guarantee issued by a holding company for the benefit of its foreign subsidiary. Let's go to Neha for the case details.
Sure, Asha. The TPO concluded that the provision of corporate guarantee is an international transaction and guarantee fee charged by the assessee was at a lower rate. The TPO reasoned that banks and companies were charging at least 3% for providing guarantees, which was the benchmark arm's length price for the corporate guarantee given by the assessee.
The matter reached the Bombay High Court, which held in favor of the assessee, concluding that when the assessee had charged a rate higher than LIBOR for providing loans to its AE, no adjustment was called for. Let's see the details of the decision.
The High Court held the considerations which applied for issuance of a corporate guarantee are distinct and separate from that of a bank guarantee. The comparison is not as between like transactions but between guarantees issued by the commercial banks as against a corporate guarantee issued by a holding company for the benefits of its AE.
Our next case relates to the taxability of shipping income from a foreign vessel in the hands of an Indian assessee. The interesting question in this case was when the statutory liability for tax payment was assigned by a UK-based entity to an entity based in Bahamas with which India has no DTAA. Will the Indian assessee be eligible for the benefits of the tax treaty under Section 90? The assessee is HK Dave Limited, a company which works as an agent of a non-resident company. The assessee renders services relating to port and income tax clearances to foreign vessels touching ports in Gujarat. The assessee had received the income tax clearance certificate in respect of a vessel flying the Norway flag under the agency of Tramp Shipping of London, and the income was allowed to be treated as exempt under the DTAA between India and UK. Let's get the facts of the case from Neha.
Yes. After grant of exemption certificate, the tax recovery officer subsequently noticed that the freight was paid to the UK-based ship owner through the charterer from Bahamas. Hence, revenue concluded that the tax liability was of the charterer of Bahamas, with which India did not have any double taxation avoidance agreement. Hence, the shipping income was taxable in the hands of the assessee.
The tribunal concluded in favor of the assessee, holding that it is a fact of taxability under a statute rather than the contractual liability under a business agreement which determines the eligibility for treaty benefits. The assessee was granted the treaty benefits. Let's look at the key parts of this decision.
The tribunal held it was wholly erroneous on the part of the lower authorities to determine the eligibility of treaty benefits on the basis of the domicile of the person liable to pay income tax dues, as it has not been the case of any of the authorities below that the income belonged to the charterer based in Bahamas and not the owner based in UK, we are unable to see any legally sustainable reasons to decline the benefit of Article 9 to the assessee.
Let's move on to our next case. The assessee is Pride Offshore International, a company incorporated in USA which belongs to the International Pride Group of companies. The assessee had provided drilling rig services for prospecting, production and extraction of mineral oil. The bone of contention in this case was whether the non-resident assessee is entitled to the benefits of Section 44BB as a subcontractor or subject to the provisions of DTAA, in which case the income earned would be taxable as royalty. Let's go to Neha for the case details.
Sure, Asha. Under a charter agreement, the assessee had delivered a rig outside India to a French company belonging to Pride Group, which was engaged into drilling activities in India for Oil and Natural Gas Commission or ONGC. In its return, the assessee declared income earned from hiring of equipments used in prospecting or production of mineral oil, which was claimed to be taxable under Section 44BB. The assessing officer held that assessee was a subcontractor and the drilling unit was not directly in use by ONGC. The income was therefore taxed as royalty under Section 916 or Article 12 of the DTAA.
The assessee appealed before the tribunal, which held in its favour by relying on the decision of the Delhi High Court in the case of PGS Geophysical. The Delhi High Court had concluded that an assessee's receipts could be taxed under Section 44BB if the assessee had a PE in India during the relevant period and if the assessee's contract entered in India was effectively connected with the PE in India. The tribunal held that the assessee was eligible for the benefit of deemed profit ratio under Section 44BB. Let's see the details of the decision.
The tribunal held that both conditions fulfilled. As noted by AO, assessee had a PE in India and assessee's contract was connected with its PE in India. Section 44BB does not create any discrimination between persons who actually do the activity of prospecting or production of mineral oil and those who supply the plant and machinery. Narrow interpretation of the provisions is not permitted. Assessee eligible for benefit of Section 44BB. Income earned from hire charges of drilling rig was taxable as business income under Section 44BB.
In our next case, the assessee is IHI Corporation, a tax resident of Japan that manufactures heavy machinery. The issue in this case was whether the assessee's receipts from offshore supply of equipment and services could be taxed within the purview of Section 9(1) as royalty. Neha has the details for us.
Yes. The assessee provides research activities and a wide range of offshore and onshore services to its clients. The assessee's Indian PE receives the consideration due to assessee in form of offshore and onshore portion of the work done. The tribunal held that the amount receivable by the assessee in respect of offshore supply of equipment and services could not be taxed under Section 9(1).
The matter reached the High Court, which relied on the landmark judgment of the Supreme Court in the case of Ishika Wijma Harima Heavy Industries and held that apart from non-applicability of Section 9(1), Article 7 of the DTAA between India and Japan was applicable and hence income arising from offshore supply of equipment and services was not taxable. Let's see the details.
The High Court held the income derived by an assessee from offshore services, though chargeable under Section 917 but exempt under the DTAA, cannot be charged to tax in the light of Section 90 subclause 2. The Apex Court in assessee's own case has held that apart from non-applicability of Section 9(1), Article 7 of the DTAA between India and Japan is also applicable.
In our last case of this episode, the assessee is Delta Airlines Inc., a USA resident that carried cargo and passengers in international traffic on its own aircraft as well as in third-party aircrafts. The assessee simply booked its customers on international flights operated by third parties from India under code-sharing agreements when it was not able to provide seats or space on its own aircraft. The dispute in this case was whether such code-sharing could be said to be a pooling arrangement eligible for exemption under Article 8 of the DTAA. Neha has the case details for us.
The assessee claimed that its arrangements with third-party carrier amounted to pooling and were covered under Article 8(4) of the DTAA. But the assessing officer ruled otherwise. While the AO allowed the assessee's revenue from services performed by employing its own airlines as exempt under Article 8, receipts from the services provided by the third-party carriers was disallowed. Revenue held that code-sharing arrangements were not in nature of pooling or charter arrangement as envisaged under the DTAA and not eligible for the Article 8 benefit.
The tribunal held in favor of revenue, holding that code-sharing agreements for booking of space or seats neither involved any pooling of funds nor sharing of profits, and the assessee was not eligible for Article 8 benefits. Let's have a look at the decision.
The tribunal held, to be eligible for Article 8(1) benefit, profit must be derived from operation of aircraft in international traffic that are owned, leased or chartered by the assessee. Under code-sharing agreement, assessee merely booked the tickets and actual transportation was done by third parties. Assessee had no fixed or exclusive booking rights. Such code-sharing was not in nature of slot or space charter, and such profits cannot be said to be profits derived from international voyage to qualify for Article 8(2) benefit. Assessee was more of a booking agent and not a charterer.
Well, this brings us to the end of this episode of Legal Wrangle on International Tax. Hope you enjoyed it. You may write to us your comments, criticism and counsel at editor@tioltube.com. Please do subscribe to the TIOL Tube channel on YouTube. It's free and it will keep you updated on our new posts. Have a good day.